How do I know when someone lacks capacity to make decisions? Losing capacity is strictly decision and time specific. Having dementia does not mean that someone's lost capacity. The Court of Protection is often called the most aptly named court because it protects people who are vulnerable. Nobody should have to have their care home fees topped up by a relative. But the best thing you can do for yourself looking forward is make a power of attorney for health and welfare and choose your attorney carefully. Hello and welcome to this episode of my podcast where we're continuing with more of your questions. Today's questions have been put together on the subject of capacity, care and how it's paid for. Most of the questions have come from you, the audience, about your fears and worries for your parents as they age and what happens when these type of issues flare up. And the first question is, how do I know when someone lacks capacity to make decisions? That's a really good question and a really interesting one. There is obviously no one answer to that, but the signs are that maybe you find yourself repeating yourself to somebody, telling them some information and they haven't retained it. There is a legal test for assessing someone's capacity, but I'm not going to just repeat the legal jargon, but if you want to go and look it up, it's in the Mental Capacity Act 2005. But really, it's about somebody understanding what you're saying to them, weighing up the scenarios that you're putting to them or their reasoning behind it, answering the question, but then retaining what they've spoken about. And it's that retaining bit that is often the first clue that somebody is maybe beginning to lose capacity. So if you're constantly repeating yourself, then maybe there's the beginnings of the lack of capacity. But we can all be forgetful at times, of course, and it's really important when we're assessing capacity to remember that there can be a reason for it. If somebody's unwell, older people tend to suffer from some illnesses that can bring about a temporary confusion, a loss of capacity like water infections. But when they're treated with antibiotics in hospital, the capacity and the level of understanding returns. Losing capacity is strictly decision and time specific. So if you are asked at a particular time about something and you don't have the capacity at that time, then that's what counts. It also depends on the scenario. Interestingly, for example, the threshold for having capacity to agree to marry somebody is quite low. You just have to understand the concept of marriage. Quite surprising because it's such an amazingly big decision to make. And yet the registrars who marry people, they just have to be comfortable that people understand that basic situation. But the capacity to make a will is a much higher threshold because you have to understand the nature and value of the assets that you've got, the obligations that you have to people, the impact of what your will might be, and then you have to retain all of that and be able to have the same type of conversation maybe a week later. So those are the different types of tests of capacity. Obviously, on the whole, lawyers, particularly those that make wills and deal with probate, are asked about the level of capacity for managing finances and property. And again, we have to think about who was this person earlier in their life? Were they ever able to manage money in the same way that you do? It's about that person's own level of capacity, not comparing it to somebody else. So get back to the question, how do I know when someone lacks capacity to make a decision? It's about your instinct, probably, ensuring that you're not putting words in their mouth to give the answer, that you're not unduly influencing them. But no one scenario is the same. Takes me on to the next question, where somebody has written, my mum has dementia. Can we sell her house to pay for her care? Well, for a start, having dementia does not mean that someone's lost capacity. You can have a diagnosis of dementia, but still have capacity. There's treatment now, there's medication that slows down the progress. And if you've got dementia but are fortunate enough to get an early diagnosis, then you can start taking that medication and it should lessen the rapid development of the illness. So if your mum's got dementia, it's about, does she have capacity to understand the selling of her home? Really, you need to consult her, take into account her circumstances. The question is, can we sell her house to pay for her care? The logistics behind selling someone's house obviously involve somebody signing a contract for the sale, and so you need a power of attorney to sell on behalf of somebody else. If they haven't got a power of attorney document and they lack capacity, then you need to go to the Court of Protection, which I'll move on to later. But if your mother has dementia and she's able to understand matters such as selling her house, then obviously you consult and you work with her. If she goes into care and is never going to be able to return home again, and you need the money from that, and you have got a valid power of attorney and she lacks capacity, then you can deal with it yourself. So lots of parts to that answer, but that's the basic part of it. So I've mentioned Court of Protection, and the next question is, what is the Court of Protection and when would you need it? The simple way of needing the Court of Protection is if someone doesn't have a power of attorney. So dementia is one thing, but if somebody has a stroke, has a brain injury following a car accident, and loses the mental capacity to deal with their own finances and hasn't made a power of attorney that's valid, you have to apply to the Court of Protection to be appointed deputy, which is like a court-appointed power of attorney, really. And that gives you the right, if your application is approved and the court order made, to deal with someone's finances and property for them. It doesn't necessarily mean you've got the right to sell their house. These days, the Court of Protection require an additional application for that. The reason for that is that they want to ensure that you only take steps you have to take on behalf of someone. So if somebody is in a care home but really recovers enough to return home with a care package, they don't want to see that that person's house has been sold when it could have been kept if they wanted to go back home. Going back to the capacity question, it might be that someone's able to express, I want to go back home. I want to live at home with care. And then you have to reveal that their house has been sold when really it didn't need to. So the Court of Protection is there to appoint deputies. It's also there to sort disputes out. So if somebody has a power of attorney and someone else says that person's abusing that person's finances, you can make an application to the Court of Protection for the lasting power of attorney to be overturned. The Court of Protection is also there to deal with people's welfare. So if, let's say, two parents of a young man aged 19 who doesn't have mental capacity because he has additional needs that mean he can't understand things such as agreeing to an operation, and the parents maybe don't agree between them what type of operation or care their son needs. Maybe one doctor recommends one course of treatment, one another, maybe a social worker's intervening. It will have to go to the Court of Protection, and the Court of Protection judge will make an order as to what's to happen to that young man's care. The Court of Protection is often called the most aptly named court because it protects people who are vulnerable. It's come under a lot of criticism, but it needs to be there really to protect people who can't make decisions for themselves. Talking of vulnerability, the next question is this. I'm worried my relative is being financially abused. What should I do? Probably the first thing to do is to ring the local authority. They've got special safeguarding departments where they will investigate what you're saying. They have the powers to do so under the Care Act, and indeed they have the obligation to do so. So they'll raise a safeguarding alert and they will start to look into what you're saying. You will be part of that investigation, although you may not be told everything because of confidentiality. But they're normally very good at fulfilling the safeguarding. What is the outcome of it? Well, the outcome could be that the matter is referred to the Court of Protection, even to the police. So there is an offence called fraud by abuse of position, which comes under the Theft Act, and that is where somebody like a power of attorney person or even a court-appointed deputy who has got an official role in looking after someone's finances but is abusing that. They're abusing their position and they're stealing from the person. That's a crime separate than a normal fraud or a theft because you're in a position of trust and it's treated really, really seriously. But you obviously need the evidence to put it to the police in the first place. Quite tricky taking financial abuse cases to the police because imagine a situation where the police go along and they talk to your elderly relative and then they say, "Did you give your son £50,000?" And the elderly person says, "Yes, they needed it. It's my son, you know." And you're thinking, yeah, but my elderly relative doesn't understand anything, or they were threatened. But the police are hearing a person saying, "Yeah, I just chose to give that person that money." So fraud by abusive position is really hard, as is financial abuse, but there's been a lot of stories in the press around it. And if you really do think somebody's being financially abused, I would say it's our social responsibility to take it further. Go to the local authority, report it as a safeguarding concern, go to a solicitor, go to the Office of the Public Guardian. You can do a search to see if there's a lasting power of attorney. It's really worth exploring if you're concerned about somebody, because the other important thing to know is that financial abuse is normally going hand in hand with another type of abuse, emotional abuse, neglect, something else. They're really sad and upsetting stories. Then the next question that we have here is, can the local council force someone into a care home? Not really. Local councils get a bad press for taking away people's homes, selling them, putting them in care homes. That isn't really what happens. Going back to the Court of Protection scenario, yes, if somebody is really at risk at home, has got no one to look after them, and no one is doing anything about it, then it is the local authority's duty to look after that person. But they can't just physically get hold of someone and dump them in a care home. They have to go to the court, go to the Court of Protection, and they have to get an order to be able to step in and deprive that person of their liberty, because that's what it's called. The deprivation of liberty safeguards, shortened to DOLS, DOLS, is a particular piece of legislation because we're not allowed to take someone's freedom away from them without authority to do so. So, for example, we take people's freedom away from them when they go to prison, but that's because a court has sentenced them to go to jail. We take people's freedom away from them when they're sectioned under the Mental Health Act, but that's under the Mental Health Act, there's a court order. And if somebody's in a care home and they haven't agreed to it and they don't understand it, that's under the deprivation of liberty safeguards. Really serious to take away someone's freedom, and that's why we have legislation and laws to protect people in that. And then this next question is a very big one. How are how are care home fees actually worked out, and will I lose everything? So, no, you will never lose everything if you're paying for a care home, because our rules are that everyone is left with £23,500. That's the threshold that we're allowed to keep. But yes, you could pay everything else down to that. So you could use all your sale proceeds of a property to pay for care home fees. The way they are calculated is that if you have over £23,500 in capital, then bearing in mind you also take into account your income, you will be paying for your own care home fees. Whether you go to a care home that's basically run by the local authority or private. The only help you get towards cost, if you have the money above that, is if you are entitled to funding from the NHS. So all of us know that NHS care is free. If you go to A&E with a broken arm, you are not asked whether you need to pay for it or not. It's free. So if you are in a care home, but most of your care is proper nursing care that's being given to you, being administered by medically trained people, then quite likely you're entitled to some or all of your costs being covered by the NHS. It's called continuing healthcare. And it really comes from the time when we didn't have care homes and people were in hospital. So if the care that you're receiving is a bit like being in a hospital, you should definitely ask for a CHC, Continuing Healthcare, NHS funding assessment. They're complicated assessments. They assess all your medical needs, but the outcome could be that you will be entitled to either part or all your fees paid by the NHS. There are other ways of getting financial support. There are certain welfare benefits that are non-means tested, such as attendance allowance or PIP. And if you have certain additional needs, you can apply for those. And it doesn't matter how much money you earn or have in your savings or capital, that will go towards it. So it's a complicated framework. But if you or your loved one is in long-term care, it's worth early doors getting that checked out and seeing that you've got the correct assessments. If you don't have money or your loved one doesn't have money and the local authority are paying for the care, then be a little careful if you're being asked as a family member to top up the care home fees, because nobody should have to have their care home fees topped up by a relative. Top-up fee is a choice. If you would prefer your loved one to have more luxury than is provided, but non-essentials, then you can choose to pay extra for, let's say, a single room rather than a shared room, or an ensuite maybe rather than a shared bathroom. But first and foremost, make sure that they're getting everything that they're entitled to. You shouldn't have lesser care when the local authority are paying than if you're paying for it yourself, because everyone's care needs they're entitled to have their care needs met. The last question today is, what if there's a disagreement in the family about someone's care? So this will very much depend on whether the person having the care has got a power of attorney. Who is that attorney? Comes back to it how important it is that you choose the correct attorney. So if you have a health and welfare attorney and they're making a decision about the care and you don't agree with the choice that attorney's making, it's really about why you're disagreeing with it. If the attorney is being neglectful of their role, the person is being harmed, then that attorney's role, they're not doing it properly. But if it's just a difference in opinion from you, they've been chosen to be the attorney, and you would probably struggle to say, that's not what I want for mum. Obviously, in an ideal world, it's best that everybody gets on. Now, if there is no attorney, it's more tricky. If there is no power of attorney for health and welfare, and two people close to somebody are disagreeing about their care, ultimately the Court of Protection will be the decider. And how will they decide? They will decide in what's on that person's best interest, because that is the rule that we have in this country. For someone who can't make decisions for themselves about their health and welfare, it's a best interest decision, and that will normally involve a doctor, a social worker, and people close to that person. Multidisciplinary, getting together with an assessment to work out what is in that person's best interests. Your starting point, if you're unhappy about the way someone's being looked after, is start with the local authority. We mentioned safeguarding earlier in this episode. That's a good place to start. Go to a lawyer of your own. There's also something called an advocacy representation, and you can go to an independent advocate, and they are people that stand between being, let's say, a family member and a solicitor. They're often charitable causes, and they could go out, visit the loved one with you, see what's going on, see if some form of mediation can take place where a decision's reached. Because at the end of the day, we're talking about an ill person who needs to be looked after, and they can often sense if there's stress around them. So, But the best thing you can do for yourself looking forward is make a power of attorney for health and welfare and choose your attorney carefully. So we've covered a lot of very sensitive issues in this episode, coming at it from the person who is at the centre of needing care or decisions made from them, and then bringing it back to thinking what you can do yourself looking forward to try to make sure that you're looked after in the way you want to be looked after by the people that you want to be looking after you. So thank you for listening, and thank you for all your questions. There were some complex ones in there, and I hope that I've answered most of them and given you the answers that you were looking for. You can email me at yourquestions@melindagiles.com, and I will answer as many of them as I can. Till next time.